Everyone. I welcome us all to this session today. It's planned to be an interactive session amongst us. It's an opportunity to continue what we started on WhatsApp for the past 1 week. Since Tuesday, we started a series which we titled What the Contract Says. It was in an attempt to make our members more familiar with the conditions of contracts. We know there are so many cases wherein members don't get to go into the contract until probably an issue occurs on site. So we thought of an opportunity for us to look into these conditions while we are actually at home, isolating or enjoying the break, more like taking the good advantage of the situation we are in at the end of the day. So today we have 3 of our facilitators who have been assisting us in doing all that we have been doing all the while on WhatsApp. We thought we had so many feedbacks, and in one of those feedbacks is that people wanted something that they wanted an avenue wherein you can have a one-on-one with the facilitators, maybe have their questions answered directly on Zoom, on a much more interactive platform. Once again, I welcome all of us here. It's a pleasure having us. We thank you for coming in. So without wasting much of our time, I would love to introduce our facilitators. In no particular order, we have YQSF EBENEZER ADAGBADA with us. He's a member of the Nigerian Institute of Quantity Surveyors. He works with HOS Consults, and well, welcome YQSF EBENEZER.
Thank you.
Okay. So we also have QS AKWA Victor. He's also a consultant. He was one who did the introduction into the contract for us on WhatsApp, and we love the session he gave to us. QS Victor too has an MSc in construction management, and he's an MNIQS too. QS Victor, welcome. Okay, I think his mic is not muted yet. It's not muted yet. Okay, the third person we have QS ADAGBADA. I want to be sure he's online yet. I don't think he was complaining about some technical issues. Okay. I'm not sure he's in yet. Okay, so moving on, we'll move on to the next thing. We want to have an overview of what has been going on. Yes, Victor, welcome.
Yes, good evening, Doctor.
Okay, so we want to have an overview of what has been happening all the while on WhatsApp. We want you to share with the online audience. We are aware of the fact that some persons have not been part of the session. So we are looking at us giving us more like a rundown, very, very brief in 5 minutes each. Each of our facilitators will just give us a rundown of what we've been doing over there on WhatsApp for the past 9 days. So I will start with QS Victor.
Thank you, Doctor. Good evening to everybody. Like I said, my name is Victor AKWA. I'm standing for about a week or more now. We've had a series of sessions on WhatsApp on a couple of sections in the conditions of contract. we just proposed it with both the NCI and also the JCT. Basically, I was started with introducing what contract means, definitions, and what we have to know, what constitutes an offer, what constitutes an acceptance, and what do you mean when we say validity of contract. I proceeded to having a session on completion, practical completion, damages, possession, and contractor design portion. After that, there was also a session that I held on variations, and I was also supposed to cover insurance, which I hope I'll be given a little time today to cover. That was basically what I handled for the series we've been having. Thank you, Doctor.
Okay. All right. Thank you, Victor. We enjoyed your session. We had the very elaborate introduction. I enjoyed it. At least I was saying that one of the things I got from that session was the fact that the fact that if you breach a contract, there are damages that you can be sued for. So it's just like the relationship between a contractor and a client, an employer. If the employer refuses to hand over the site to the employer on time, to the contractor on time, he pays the damages in either extension of time or even monies. So over to you, QS Ebenezer. Can you give us a little rundown into what you did with us on WhatsApp? QS Ebenezer.
Okay, all right. Good evening, everyone. Hope you can hear me.
Yes, we can.
Okay, good evening. Okay, let me, sorry, as my tradition is, I must first of all appreciate everyone on board, especially our guys in the industry, you know, people whom we have known before we even knew we were going to study quantity surveyors, the immediate past president of the and every other person in that category you actually recognize. Let me quickly do my own overview of what we've been doing in the past weeks. First of all, I was assigned the responsibility of going through what the contractor's obligations are. But there is one thing that I would like to actually mention in that contractor's obligation. Is that irrespective of whatever happens, the contractor has the obligation to start and complete the work in a workmanlike manner according to the terms of the contract, in terms of the quality of the works and the quality of goods and the workmanship. But I would want to actually say the word workmanlike manner actually emanated from what it used to be. For instance, if you have employed me to do something in this environment, for instance, you know, how do other contractors do the work? So that is workmanlike manner. And it's a debatable word, because what is workmanlike is laziness in that environment. All right. So obligation to start and complete the works, to give notices as at when due and the like. So after that, I also took the aspect of access representatives and third-party collateral warranty, and we're made to understand that the collateral warranty and third-party are not actually, it's like another party. I mean, liability, or how do I call it now? When you enter into a contract, two parties enter into a contract, and you now give the right to a third party to enforce the right of one of the parties in the contract, the third party that is not actually a party to the contract. So if it is not all in all contract that can actually operate, for instance, if it's supposed to run on the contract, it would have been identified in the part 2 under the contract particulars that there's clauses 7, A to E. I don't know if you heard me in most part of what I said, because I actually observe that it's like most people not here.
You can do a quick recap.
All right, like I said, the part one of what I handled was a contractor's obligation. The key to contractor's obligation is that he has been contracted to do a work, and he must do that work in accordance to the terms of that contract, the quality expected of works and of workmanship, and in a workmanlike manner, irrespective of whether there has been subletting or what. Then again, I also handle the aspect of assignment, the third-party warranty, and I said that in any case, if any of the party wants to assign the contract, there must be notice that must be given. If you want to take a decision that affects the contractual relationship between the client, the employer and the contractor, there must be notices given to the other party. Okay, so I also talked about this toggles of a third party who is a beneficiary of the product to bring to enforce the right and obligation of one of the contracting parties. So suppose you have a tenant that is occupying that is going to occupy the building, for instance. So that tenant within a reasonable period, based on whether the contract is under seal or under by hand, within either 6 months or 6 years or 12 years period, the tenant can bring a proceeding to enforce the right of the employer under that contract. So those are the major highlights of the things I handled in this session. Thank you.
Okay, thank you very much, QS Ebenezer. Yeah, I'm not sure we have QS ADAGBADA yet. He was complaining of difficulty in connecting. I can't see him here now. So without his own side, I remember he was assigned to take. He took. Okay, BERTHRAN took us through the errors, discrepancies, and divergence in drawings in the contract documents. He talked about the CPD design work. He also talked about fees, royalties, and patent rights as it concerns the project. Then also on fixed materials and goods, property rates, etc. He also went on to talk about the contract sum and adjustment, and it was at that point we're talking about him being a contractor and being someone who think, as the maybe should I say rights or the privilege of talking about that kind of topic. Talked about payment, the certificate and notices, gross valuation, retention, fluctuations, loss and expense, and all that. So he was one who also ended the session with us. He just told me he's having connection issues now. Apologies. He talked about the schedules. The schedules, we were talking about the schedules at the portions that talked about more information about most of the contract clauses that we have above. We talked about the contractor's design, submission, variation and acceleration quotation procedure, quotation procedures. Talked about insurance options. We talked about the code of practice. Talked about the third-party rights. Talked about the forms of bonds, fluctuation options, and supplementary provisions. So those are the things we talked about generally. And today, having such background, we are moving on to take the opinion of our facilitators on what they think. Like we've talked about generally about these contracts. What if you are going to talk about on construction contract generally? How are you going to talk about it? What is the uniqueness of construction contracts as against maybe other contractual obligations we can have about, we have business law, we have property law. What do you think makes the construction contract itself really unique in itself? Let me start with QS Ebenezer this time.
All right, thank you very much, QS Dotun. Like we have always been told that construction contracts, I mean construction generally, the construction industry is nomadic in nature. You know, in other words, you might have a contract, I mean a project situated in Lagos. Even within Lagos, you have different locations and the like, and you know that each of these locations has its own peculiarity. For instance, you want to enter a contract in, you want to build a contract to build, let's assume in somewhere like Aja, all those areas that has, prone to a lot of money issues and the like. You know that you have to allow for a lot of risk and the like. And today in Nigeria, we have branded it, what do they call it? I say PR. A lot of other settlement and the like. If you want to build a banana, those things, you would have priced it in your, sometimes in the preliminaries, or the client just take care of those items. You have to pay a settlement, some things to enter into. You want to bring in material and the like. Okay, for instance, you have another contract to build in, let's say, Bonny Island, for instance, in Port Harcourt, that you have to go through the IC. You have a lot of that place that is prone to a lot of pirate and the like, movement of your staff to and fro the place. You need to think of a lot of things. So, so it could even be the same simple building that you want to do somewhere in Banana Island that you're going to be doing there. So the risk is different. It doesn't, the risk that the inherent risk in any project does not really have to do with, does not necessarily have to do with the value. Value is part of the risk anyway, but you look at the nature of the environment. Unlike in production, for instance, you already have your production line. You want to produce, what do you call it now? Let's say 3 crown milk, the production line, you put in the formula. The formula is the same, everything is the same. Whether you want to produce for use in Katangura, anywhere in the world, the production process is the same. But on any construction project, there is peculiarity in any of those projects. And so that is what makes the construction contract to be peculiar in nature. So you have to pay attention during the formation of the contract to a lot of risks that you are likely to encounter on the project based on experience of the environment and other things. Material, especially even material supply. So thank you.
Thank you, QS Ebenezer. Thank you for that introduction. So, QS Victor, please, can we have your own input in that regard?
Okay, for me, like QS Ebenezer has said, the construction industry is full of so many participants, and these days you even have individuals or parties which never existed before. You now have developers in the industry. We have facility managers in the industry. All of these never existed before. How do you capture this relationship? It is through contracts. But like I keep saying, contracts is based on a doctrine of entirety. You do your whole part, I do my own part. What separates construction contract from operation, which in most contracts you don't find? The ability of the client or the employer to change something. That sets aside the construction contract from every other type of contract. In business contracts that we have, or in normal industries, you have to ship somewhere, the other person has to can go to the courts and get reprieve in that particular section for settlement. Now, another part that separates the construction contract from other kind of contracts is that what we have in a particular area will not apply in another area. Like Ebenezer said, in Aja, you might just move away from Aja a little bit and come to Victoria Island. The conditions, the terms are very different. One thing I want us to observe and know that most contracts, condition of contract, usually consist of majorly 15 terms. 15 terms must be present in every condition of contract, 15 of them. One, we have a statement confirming the project, how it to be carried out. The second one, we have the price. Then thirdly, we have the name of the parties. And fourth, we have the list of the conditions. Then we have the law that are applicable. We have how the contract is supposed to be executed, the contractor's obligation. We have the client's role. We have the rights of the client, the method of payment, the method of security, the provision of insurance, procedure for settlement, and the length of the deferred liability period. These are the 15 constituents of most construction contracts. Let me also tell us that it is advisable most times for us to stick with the standard forms, because over the years, the professionals that have designed and put together these various standard forms have experienced the devil you know than to go ahead and work with the angel you don't know. So in conclusion, I'll say,
thank you, Victor, for the insights, the uniqueness of the construction contracts. Thank you for those 15 points which we have noted. AKWA has been able to connect successfully. Thank God. Here's AZUBIKE. Good evening to you. Oh, we can hear you. Are you okay? Oh,
can you hear me?
Oh yes, we can hear you, but it looks quite. It's looking like the reception over there is not too good.
Looks.
Oh. Unfortunately, it seems your connection is not too good.
Let me try. Can you hear me now?
Okay, we can hear you.
Trying
can
to.
Hear you.
All right.
I can hear you now. I can hear you.
All right.
Okay. You've seen where the conversation is coming from.
Yes, I've seen where the conversation is coming from, and it's overview of construction contracts.
Okay.
Based on the sections taken. But from my understanding, hello, can you hear me?
Yes, although I've taken that on your behalf. I don't know if you have any additions. I just laid out the areas you took. I don't know if you want to go into what we're doing now, which is talking about the uniqueness of the construction contracts.
Okay. Let me go to the uniqueness of the construction contract.
Okay.
In addition to what QS EBENEZER and QS Victor have said, they've said a lot. What I am going to add is the construction. What makes the construction contract very unique is it sets out responsibilities and obligation between the parties. It sets out what do's and don'ts that the contractor has to do on his own part, and do's and don'ts that the client and the consultants on the part of the client have to do on their own part. And it also sets out the powers the architect or the contract administrators have over some responsibilities and obligation. Like for instance, you cannot ask, the architect cannot ask a contractor to carry out a work outside his scope. You understand? The contract, okay, which includes every other document, sets out the scope. It tells every party what and what that needs to be done, where there limitation of power is, what they need to do and what they don't need to do. And it's also unique in the sense that it dishes out the penalties, will I use the word penalties, or consequences which each party has to bear if these conditions are not met. For instance, if the client has to deliver a certain size or a certain client material within a specific period of time as stated in the contract, and it wasn't done, there should be a penalty, there should be a consequence to that. And getting these consequences, there are ways that has to be followed by the contractor. In order not to take more time, let me stop at this stage on that.
Okay, thank you, Azubi. Yeah, let me just move to the next thing. We know that we have various types of conditions. We talked a little bit about those conditions. We talked about the FIDISH conditions and the JCT conditions. So we'll just need a little insight into what makes these two types of conditions really different. What are the main catch? What is the catch really between the FIDISH contract and the JCT contract? What are the main differences we have? You know, you try as much as you want to suit your project to your conditions to one particular project. So I would like Ebenezer to give some words about that. What's your Ebenezer? Okay.
All right. Can I go on? All right. I've worked more with JCT, but I've worked with FIDIC condition of contract, a specific type of FIDIC which is meant for World Bank. There's a FIDIC meant for World Bank, though extracted from the main FIDIC. I've worked with FIDIC. The area that I found very, very different from JCT is in terms of variation. There's a clause in FIDIC contract that says that once the engineer issues a variation instruction, are you with me?
Yes, I'm with you.
Once he issues the variation instruction, the contractor is expected to carry out the work even without sending the cost implication. And I found it very difficult then when I was handling a particular project that they were using FIDIC, because they were just dishing out instruction and we are carrying out the instruction even before we send out the cost implication. And I think the first time that instruction came in, I sent out a cost that I'm not going to carry out this work unless they approve the cost. And I remember then the project manager was like, no, remember you're using FIDIC contract. It has to refer me to a particular clause in that FIDIC that you have to carry out that work immediately, even without getting the cost approval. And it's kind of different in the case of JCT. JCT, there needs to be some kind of approval, not only on the work, but also on the cost for this work to go on. This is the main difference I've seen between JCT and FIDIC. Thanks.
Yes, Ebenezer, do you want to dwell on that? Say some things.
All right. Maybe just a little things I would have to say. In addition to what QS AZUBIKE has said, one of the things I find very interesting about FIDIC, I have never used it on any contract, but I have taken my time to study it when we do some review in the office and during my master's program as well. The language of FIDIC is very straightforward. Very, very straightforward. You can easily understand it, except you don't understand English. Apology to say that. Okay. Then JCT seem to be operating within a closed cycle. When you look at the way it is put together, you see a lot of references to the country of origin. But in FIDIC, it is suitable for international contracts. They would even refer to the country under the interpretation as the country where the project situates. You know, even the currency, they would refer to it as what is in the schedules, or otherwise the currency of the country where the contract actually operates. Then some language, and the old format of old editions of JCT, you find the word like determination to mean what termination now refers to. But in FIDIC, determination actually has to do with determining the value of the works, going to try to determine the value of works, and it put the responsibility of determination on the engineer instructing the contractor to come, so that and if the contractor doesn't agree to, I mean, if it doesn't show up, if he's been given an adequate notice and it doesn't show up, then the engineer can do his own assessment, and whatever he has done is binding on the contractor, you know. So it's very interesting, to be honest, because of all these simple things. In terms of a dispute resolution, I think it's about the arbitration. I think it gives about 84 days. 84 days. You know, when the matter in arbitration can be referenced. You know, unlike JCT gives like initial 28 days and another 14 days of notice. So there are little differences and little tweaks. You have issues like a defect liability period. It's referred to as defect notification period, you know. So we can read more.
Okay. Yeah, thank you. Thank you. I think in addition to that, I remember when there was a session I attended about on FIDIC, where we talked about the fact that the adjudication process is different. In FIDIC, you have to decide the adjudicator from the beginning of the beginning of the project. Then some other areas too, you know, FIDIC has a provision as JCT just has LAD, FIDIC has a supplementary conditions which allows for the contractor to have extra when he completes the work faster than envisaged. So more like some incentives here or there. But at the end of the day, I think the whole message is that we have to look at what we have. Yeah, we have to look at what we have to be able to get what we need next. So next, I will want to talk about a little about the insurances, because AKWA was the one who handled insurance on the WhatsApp session. I want him to talk a little bit, just a brief about insurance as it touches construction.
Thank you very much, Dr. I'd like to start with a little definition of what insurance is. What insurance is taking the risks of a few people and sharing it among many. What do I mean by that? It means, for example, our normal car insurance. It does not necessarily mean that any issue, but it might be a 1 in 100 that may have the issue, and the money that has been paid by all others is used to take care of the duty or the problems of the other party. The insurance is being covered in Section 6 of the contract conditions. And basically, from 2 types of insurance. We have the liability insurance and the loss insurance. What is liability insurance? For legal liabilities that is being owed to others. What does the contract? When we've created the rights and obligations, what the insurance does is to help to cover your own part. If there is what we call third-party insurance, that's what liability insurance does. And second part, the loss insurance. You just provide loss cover for losses, which falls on the insured parties. What does that mean? That tells us that for you that have approached the insurance company for cover, the loss insurance will take care of your own risks or the problems that may arise. Now, what does clause 6 or section 6 of the BCT say, or the NCI? It tells us that the conditions to indemnify the employer injury or death to any person arising from or in the course of carrying out the work. This tells us that the contractor will take care of any issues that may arise when he's carrying out the work, for which we're supposed to get to the employer. Then if we move further downward, section 2, section 6.2, we are told that it requires the contractor to indemnify the employer in respect of any expense, liability, loss, claim, or proceedings arising from injury or damage to property, real or personal injury to property. What this tells us is that the contractor is to indemnify the employer from expenses, liability, losses, and the like. Further forward, there's also an indemnity that the contractor is supposed to provide to take care of the losses that will come to put. Now, for example, there are adjoining buildings. When you have adjoining buildings, and in the midst of carrying out the work, there is an issue. It might be that the excavation has affected the foundation of the fence of the adjoining building, or due to a breaking up, it has caused crack. The contractor is to indemnify the employer from such losses. Now, further forward, we also have that in trying to cover the employer, there has to be evidence of insurance from contractor. You don't go and tell the employer or the contract administrator or architect in the case of the CI that you've incurred a loss without the evidence to show you have taken care of those issues that has come up. Now, the loss clearly the length or the timeline for provision of insurance or cover for project is not in any of the conditions. We have been advised that you should take the insurance cover up to the end of the rectification period, what we call defect liability period. From the start.
The next question will be directed to QS AZUBIKE. Can you help us with a brief of what to cost to the client, the do's and don'ts, what to put into consideration? Did you get the question? QS AZUBIKE. What to put into consideration when forwarding a claim to a client?
All right, thank you. Putting forward a claim to a client, there are steps as a contractor. There are steps that needs to be taken. You don't just feel, I need to claim for this, and then you put a claim forward. It doesn't work that way. First, the claim there must be a provision, there must be a contractual provision in the contract. Say for instance, you are putting forward a claim for loss and expense, for instance, for a particular item. There must be a clause in the contract that you are backing up your claim with. You need to first identify that provision in the contract, know how it affects your claim. But then, before you put forward a claim, you don't just put forward a claim even after knowing those clauses. You first have to give a notice. A notice has to come first before a claim comes in. Let's say, for instance, the client, you have a part of your contract that says sanitary wares will be supplied by the client. And a time in your program, the sanitary wares as we supplied, let's say on the 25th of June, you first of all put up a notice of delay. Reason is this: you don't put up a notice of delay 2 days to the day that the ties or the wares has to be supplied to site, or 3 weeks or 2 weeks. You need to put it, let's say, like a month to that time or 3 weeks to that time. It has to be within a reasonable period. You put up a notice to the architect or the contract administrator that we are still expecting these items on site. We are yet to receive this item. It has to be in a formal letter, not just a mail. It has to be in a formal letter. And aside from that, in your letter, in your notice of delay of those items, you need to state the contract provision that affects that. Also, you need to state what will be the effect of the delays of these client supply items if they don't get to site on time. You send a notice to them, the first notice. You can also send maybe a week to that time when the ties are supposed to arrive. You send another notice. Maybe you send another notice, then maybe a few days to that time, you send a letter, a claim. And your claim must specify the cause and effect. These are the two items that comes in the claim. There must be a cause, there must be an effect. The cause here relates to the events. What are the events that leads to this? Then the effect here is the impact. What impact will this delay of these items cause on the delivery time of the project? Let's say, for instance, the client is supposed to supply ties. You know, if there's no ties on site, if you don't install your ties, you cannot start up painting. If you don't start up painting, you cannot hand over the project. I mean, the wall painting, you cannot hand over the project. So there will be an effect on the delivery time period of the project. And in your letter, you need to state what extension are you looking at? What is the cost implication? Because if there's an extension to the delivery period of that project, it's going to lead to additional manpower. It's going to lead to additional premium and the rest of them. So what I'm looking at is you need to understand the contract provision. You need to prove in your letter that this claim is going to affect certain work. You need to do that. And again, you also need to back up. You don't just state that in your letter. You need to back up your claims with necessary documents. You need to attach maybe your program of works. This is your program of work, highlighting those works that the late delivery of ties, for instance, is going to cause. You need to attach your previous notice. In your letter, you need to reference what are the notices you have given in the past. You need to highlight them and also enclose a copy of those notices in your claim and send it to as a mail to the contract administrator or the client. But then we need to understand something here. What we need to understand is when you're sending a claim to the client, you need to understand if there are specific persons that this claim has to be addressed to. Like, for instance, some contract particulars will tell you that in any issue that relates to claim, it has to be directed straight up to the client. So you need to understand that when you are sending a claim, who are the people you need to send it to? Is it the client directly? Is it the architect only? Or is it only the contract administrator or the project manager? You need to understand the people. Otherwise, if you send your claim, if the contract particular says the claim has to be sent to the client directly, and you send it to the architect or the project manager without putting the client in copy, you may not get the necessary attention you need, because you are actually violating what the contract procedures are. Now, in the case of what are the do's and don'ts that needs to come in when you are sending out your claim, first, the do's is don't send claim without adequate notification. You need to send your notices. Notices has to go out first before claims goes out. Also, you need to make necessary attachment of supporting documents, which means that you need to have a very good documentation, records. You need to take records of events, what and what that needs to be included has to be included. You don't just generate document that same day you want to send out your notification. You generate all these and you keep sending these things out before you finally send your claim. And then for the don'ts, don't ever send your claim without contractual provisions. There should be clauses in the contract that comes in before a claim goes out. And that is it. That is it. Let's start from here.
Thank you very much, AZUBIKE, for the insights. Before I move into the next question, I don't know, QS Ebenezer, do you want to add one or two things? I believe that QS AZUBIKE did a lot of justice to that.
Sorry, I can't hear you.
Yeah. QS Ebenezer, do you have any addition to what?
Well, yes, I think as I think you have said it, you must give notice, you must know your contract, because all contracts are not the same. You cannot be treating contract B in the eye of a contract A that you have done in the past. So because contract A say you must send notice to a particular person, and you just assume that, oh, in all cases you must be sending to that same person. You have to know what your contract says, the relevant provisions of the
Okay. Thank you very much. Before we proceed, we'd like to appreciate our senior members here. We do not take your presence for granted, starting with our immediate past president, QS Femi Onoshile. Thank you very much, sir, for joining us. We also want to appreciate the presence of the Secretary, Marketing and Corporate Affairs, QS Aderonke Oyelami. Thank you very much, ma. Also, we have with us QS Bola Deera, the immediate past chairman of YQSF. Generally, we want to appreciate all our senior members here. This is very, very important. Thank you so much. We do not take your presence here lightly. We appreciate you all. Also, every other person here, we appreciate everyone for joining us. So to the next question now. This will be for all the facilitators to answer. What effects should we be expecting that COVID-19 would have on construction contracts? Also, to add to that, what's your advice for contractor, clients, and consultants? So that's our next question. So what effect should we have be expecting that this COVID-19 is going to come with? And what advice do you have for the clients, the contractor, and even the consultants? What do you want us to do? What do you want us to take note of? I think that's it. I don't know if you got the question or you want me to recap.
Okay. I think I get your question. The point is that the COVID-19 is a novel stuff. In other words, there's no precedence. So, and it's called the whole world in unaware, even the big might of this world, the United States and the like, you know, they all have issues dealing with it. Okay, coming to construction contract, we know that this is actually a disruption to the progress of work. And from my own opinion, you know, I would expect that it should be a win-win situation for both the contractor and the client. In a situation like this, I would expect that, for instance, the contractor is still having the possession of the site. So, in other words, he has his workmen in that on that project or what have you. Definitely, because of that disruption, has made some losses. For instance, if the man has actually borrowed money and the value of money is, you know, it has changed because of the effect of COVID-19 and the like. Because I had IMF saying the other day that the whole world is now at in a recession. So we still don't know what would come out of it. The exchange rate, we don't know how it's going to look like and the like. And so the issue is that it has actually caused a lot of it would cause losses definitely to the client. And you would see that I think it was a FIDIC condition that tried to mention the word pandemic. And I'm not sure if this is actually envisaged a kind of pandemic like this that is going to throw the whole world at a standstill. So I do not think anybody has envisaged this kind of a thing. I think we have also read what experts say on this COVID-19, on the coronavirus issue, you know, the relevant clauses that were provided for, you know, extension of time and the like. But in other words, what I would like to say is that in this kind of situation, we might have a situation whereby extension of time is granted and the contractor and the employer has to look at these two situations back and forth. Like just we are at home now, you know, let's consider our employment as an employer-contractor relationship. We are at home and a lot of us sometimes will be expecting the office to make some payment to us and the like, you know. So it should be a win-win situation. I've seen some companies, they have been making maybe a 50% or what have you, a rebated payment to they didn't just leave their staff without making some form of payment for them because they know that the situation is very, very difficult. And so there should be a win-win. They should look at the situation from the contractor's perspective and from the client perspective. They should be able to resolve it. But then going forward on this kind of a thing, I think this is one of the reasons why the whites are actually moving forward. In a situation like this, they'll research about it, what should be done, should this kind of situation reoccur. It's not that we are in 2020 and we're still referring to JCT 88. Thank you very much.
Any addition from QS Victor?
Okay, I wish to say that these are times nobody expected. For the contractor, I'll say this is an opportunity for you to send that mail if you've not sent one. Because the JCT, if we are going with that, or the NCI, has mandated that when it has become evident that there will be a delay and the relevant events have been stated, and from the release of the JCT and FIDIC, and also I'm not seeing one from the ICE, which is like 3. I'm not seeing any for them. It's clearly stated that we will have to take this particular event, this particular pandemic as a force majeure. If the contractor has not sent an email or sent a letter and scanned, because I've been seeing scanned letters all around, they should do that right now. Because a client that has taken a particular fund from a particular bank, the bank are expecting that he's going to pay interest at this time. So that document from the contractor can also assist the employer. So the contractor should send that notice now. For clients, this is the time for you to tighten your seatbelt, to replan and plan check your cash flows, check your plans, because there will be shortage of funds. Start looking at your financial statements. Can the amount I have finish this project? The funds that I was supposed to get from so and so person or from so and so party, will the person be willing to give me that fund now? Because everybody's in a state where they want to survive. That's the first thing. Everybody wants to survive, safety first. So clients and employers have to reassess their cash flow forecast, look at their financial statements.
Here again.
If it's possible, financial statements from your consultants, so that you know a particular source, you can go look for funds from somewhere else. And for us consultants, it is high time that we work as efficient, that's the word, efficient as possible. We have to be efficient, very, very efficient. This is nobody wants to take any laps from anybody. So we have to, as much as possible, make sure that we work very closely with our employers and also with the contractor to ensure that the project is delivered. Yes, there are issues, but where we can make savings through value on this part of a little push to
We apologize for the network. Okay.
But what do you say?
Okay. Move on, please.
Okay. So I said I see projects where we don't at the back of certain project, the back page, we don't have appendices that covers basic rates of prices of material, even for even labor too. When issues like this come up, like this pandemic now, there will most likely be inflation. If you don't have those prices there, how do you want to make your claims? So QSs, both on the contractor side and on the consultant side, we cross our T's and dot our I's. Very important. Thank you very much.
Okay, thank you very much, QS Victor. AZUBIKE, do you have something to say? Yes, unmute your mic, please.
Okay. In addition to what QS Victor said, on the side of the contractor, I want to believe it will be very much unwise for any contractor not to have sent notices of as regards this COVID-19 pandemic. I remember my site. I know I have some consultants, QS, on my site. At every point, once the government made announcement of lockdown, 2 weeks, 4 weeks, and that is the time you need to send out your notice that there will be a delay. And you don't just send out your notice once. You keep sending, each time the government extends this lockdown, you keep sending out your notices so that by the time the whole thing is lifted, you can have a very good claim to make for extension of time. So on the part of the contractor, it will definitely lead to extension of time. The completion date for the project will definitely be extended. And of course, some costs will be incurred. This is where I'm not sure if it's something that contractors may be able to claim in full. But I think something can be done. Maybe there will be some agreement or so and so forth. But I know that the project delivery time will have to be extended. And this doesn't just come automatically. As I said earlier on, there should be some official notices sent out as a contractor to the client at a regular phase. You don't send it once and go to bed. You keep sending it, and you keep sending it, and you keep sending it. Then on the part of the client, of course, it's going to affect their cash flow, as QS Victor actually said. It's going to affect their cash flow. This is the time for the client to have to sit down and then look at the items, especially if the project is at the early stage where they need to start procuring materials. Maybe they need to start looking at buying these materials locally instead of buying material, shipping materials from China or Spain. They need to start looking at that. If it is ties, there are very good ties you can get in Nigeria. This will save us, it will save the client a lot of money, a lot of headache to reduce the completion period. And as we know, most of our clients we have these days are developers. So there are people's money that are involved right now, that are involved in this project. It's time for the contract, for the clients to start looking locally to get some of these materials procured locally. And that is a little I can add to what my colleagues have said earlier. Thank you.
Very much, yes. AZUBIKE. Yeah, as I move on, I would love to, we are going to move to questions and answers now. So if you have questions, please try and drop them in the chat section so that we can ask our facilitators and our friends.
Yeah.
But before that, I would like to welcome in our midst. We have some Senate members in our midst. Of course, we have some other people too. We have QS Terence Achi Kanu, who is the HOD L&L department. HOD of QS department in L&L. L&L is a construction company, a foremost construction company. Thank you for coming. We have QS Folusho Ogurinde, who is a Senate member. We also have QS Barua, QS Afolabi Barua, who is a Senate member in MNIQS Lagos, and a host of other people. We have QS Lolade Shukoya, who is a Senate member of Lagos chapter MNIQS 2. Also, we have the pioneer chairman of YQSF, Ahmed Kabir. Kabir is here with us. We thank you all for coming. We appreciate your presence, and we appreciate your presence. So we'll be moving to questions, but I think before we move to those questions, I want on behalf of the Senate members, everybody, I want our IPP, yes, our family to just maybe help us chip in a little bit into the discussion. We are very happy, sir, for the time you are giving us today, for always being there for us, being amongst us. Sir, can we have a little from you, sir, while we take the questions?
Thank you very much, Mr. Moderator. Sorry, I didn't get your name, but generally, I would like to commend the YQSF for yet again this session, training session for the young quantity surveyors. There's something that is germane in my mind, training and the young ones. I'm happy to be with you, and of course, I'm also learning from you guys. Nobody has 100% monopoly of knowledge. And so it's good, I'm happy to be here with you. So far, I want to commend also the crop of your speakers. Unfortunately, I missed the first one, but I think they did a recap of the first outing. And from the recap that I got, it appears they really did their homework very well. So I want to commend you guys for the talks and for the enlightenment you are giving our members. Very good. And I also like the honesty of the presenters. I was happy to hear one say that, look, I've not used FIDIC condition of contract before, but based on the little I know, this and that. That's quite honorable. There's no point faking a knowledge that is not in them. So I think I appreciate the sincerity of the presenters, and I want to commend them. Well done. Also, I can see by my last review, we have about 62 participants here. It does show that we are all looking for knowledge acquisition, which is the bane of professionalism. Nobody's resting on his words, and I want to commend you guys. Yes, most of you now have your MNIQS, but that notwithstanding, you are still interested in disseminating knowledge. So I want to encourage you to please proceed along this line. This is the way to go. I believe, I'm not too sure that this has to do with ISEC Junior Organization, but eventually I want to encourage you guys to even go international, especially those who have delivered papers today or who have spoken today. We need to encourage our members to be international speakers. International speakers and thereby become international professionals and international resource persons. That way, your voices can be heard and you can be part of the decision makers of our country, of our industry and our country. So please, let's expand these opportunities and this confidence. I want to commend you. Now, having said that, yes, I'd also like to commend Ahmad Kabir. I know you're hearing me, Ahmad FNIQS. You can see the continuity of what you started. Well done. And I want to, this is a challenge to others also, to do more than just continuing with YQSF. Take it to the very next level or even exponential level. That's what we want to see. Ahmad Kabir, well done. Now, on what you have spoken about, contract, that theme or the title of today's episode was quite interesting for me. So I said, yes, I must listen to what you guys are saying. And so far, I'm not disappointed. And I'm happy with the crop of what has been said and the crop of presenters. On contractors' obligations, somebody spoke about contractors' obligation. The contractors' obligation, the major thing I want you to note there, not just the literary interpretation of the clause there. That clause, for us as consurveyors, implies that the contractor is responsible for the entirety of the contract. So the contractor is not just responsible for his own builder's work. He is responsible for the M&E and others. And that's why he must agree to the subcontractors that you're bringing to him. He can reject a subcontractor being proposed that, look, I don't think this man is capable. And if you force the subcontractor on him, he would not ask for a caveat that, well, I've said I don't want this man, is not competent, but you have insisted. So if this guy should mess up, don't hold me responsible anymore. So there'll be a caveat in that. But for us to know, that clause holds the contractor very rigidly. Many of our contractors in Nigeria, they tell you, no, I'm just a big contractor. I'm not responsible for subcontractor. No, that is the clause that ties them, the contractors, to the entirety of the project. So please take note of that. Two, there's nothing I can say anymore about the peculiarity of building contracts. You guys did fantastically, and I want you to share this knowledge. In fact, I was just taking notes about the peculiarity of the contract. All what you said is a combination of contracts, of a law of contract and building process, ability to vary the contract, set out powers and obligations of parties. I was jotting that. So for you to know that I'm also learning. You guys did a very good job on that. I'm proud of you. Now, FIDIC or JCT for quantity surveyors. For quantity surveyors, I want you to promote JCT as much as you can. JCT is the only construction contract that recognizes quantity surveyor. The FIDIC doesn't recognize quantity surveyor. It doesn't recognize the architects. So why are you promoting the FIDIC? So the FIDIC is being promoted by engineers, and they use it for what you can call engineering projects that engineers lead. For instance, what you call civil engineering projects, roads, marine works, bridges. Those are the kind of contracts. So it's basically for let's understand that, is basically for engineering, civil engineering works. Engineers, they want to apply it to building contracts. So they are looking for ways to force it on us. We shouldn't fall for that gambit, because with that, the contract says engineers. And I've seen cases in court where if somebody now goes and says it's a project manager and is using FIDIC, for instance, the first thing they will ask him, the law says the engineer shall, Mr. Project Manager, are you an engineer? Where did you read your engineering? No, I didn't read engineering. I studied keywords. I'm a project manager. Then why are you acting as an engineer? So you can be implicated. So I want you guys to please focus on JCT. That's one, JCT is for civil engineering. Two, FIDIC is for civil engineering works. Two, FIDIC is for international contracts, where you have one of the parties, either the client or the contractor, not domiciled in the country of the project. So for instance, we're having this 50-story building project we want to do. No contractor has done 50-story building in Nigeria. So we're going to China to then get a contractor from China who has done 100-story before, or from Dubai, to bring such contractors to Nigeria to do this project. Then in that kind of project, you use FIDIC, because you are bringing a contractor in. The contractor is not domiciled in your country. Or if an American company or Japanese company, they want to establish a factory in Nigeria, but they're financing it from Japan or from South Africa, because their money is coming from outside the country, the clients outside the country, they will want a sort of international contract that is internationally interpreted. So FIDIC will go for that. But where you have a building contract with the client in Nigeria, the client can be an incorporated company, but registered in Nigeria, and the project is in Nigeria, and you're using a contractor in Nigeria, please, you go for the JCT. Now, JCT, the NCI is the same as JCT. And I'm happy some of you have mentioned the NCI. The NCI was produced from the JCT 2006. So it's not so far off. The difference between 2005, JCT 2005. So the difference between the JCT 2005 and the 2016 is because of the recent laws in UK, which are not applicable to Nigeria. That's the only difference. So it's as good as the JCT 2016, but with two extra laws that were recently made around 2014, so which are not applicable to Nigeria. Now, some of these laws also that is not making Nigeria, the NCI, to be fully global form compliant. The NCI, like I said, is from JCT 2005. And the whole idea is to bring up our industry to global standard, so that what operates in Hong Kong operates in Nigeria. So a client based in Hong Kong or based in China or based in UK will be comfortable to execute a project in Nigeria, knowing that the JCT we're using in Nigeria is the current JCT. So that was the essence. Now, that's about the NCI. When I was president of the institute, we were asking for two laws to be enacted for our industry. One is the health and safety law. The second one is on the payment assurance laws. Now, especially the health and safety, we are unable to fully galvanize the health and safety parameters in the JCT in Nigeria. The NCI removed some aspect of health and safety because we don't have the laws that they have in the UK that backs up the health and safety. These same laws, they are in all Commonwealth countries. So why is Nigeria behind? And that's why we're trying to get our House of Reps in Abuja to enact this law into jail because of that collapse building. Today, early this morning or yesterday, we had about an 8-story building collapse in a way. My words, nobody will go to jail for it. Why? But if the law we're talking about is enacted, the one that we drafted, so it will bring up those that are responsible. Somebody must go, because life is sacrosanct. Life is serious. You don't just lose life and keep quiet. In this building, I heard that there are about 20-something, there were some 20-something guys under the rubbles that they are unable to get out as of now. But somebody must go to jail. Somebody must bear the brunt. The laws we have in Nigeria as of now doesn't allow that. When we're trying to push that law, some of our stakeholders in the industry, engineers, will say, look, let's just push the building code. The building code is a regulation, it's not a law. So if you flout the building code, you can go to jail. So that's why people treat it with levity. But if it is enacted, if it's an act of government, you dare not fall for it. You'll go to jail. And when you know that I want to build this, I want to develop a project, and if I don't do it well, there's a tendency for me to go to jail. I will make sure I get the relevant and qualified professionals to be there. The relevant professional will make sure they get relevant and good contractors to be part of it. And then there will be one consultant that must be in charge of health and safety. Those are the things in the bill that we have said should be enacted. So that's one. Two is on the payment assurance. This industry will do better if all consultants are paid for jobs that they do, that there are no abortive works. All contractors are paid for their projects. Government or developers don't owe people in the industry. Construction is peculiar. The size of the investment, the size of transaction could be very high. So if I do a project where a client is owing me 500 million and I'm not paid, it's going to trickle down. So we are saying payment, there must be a law to preserve our own industry, construction industry. Let everybody be paid for their job, and we will all smile. We will all do well. Staff will grow. Young ones will grow to become big consultants. Man, I pity you guys, but God will be your strength. You will grow also. You will even be bigger than us. But the system must be freed, must be opened up for you guys. But I'm happy the way you are going. Ensure you have a voice, at all levels, and this is the way to go. I hope I've not spoken too much. I've not taken much of your time. Thank you very much. Please proceed.
No, sir, you shared with us, sir. We actually appreciate the talk. We actually appreciate everything that's been talked about. Yeah, moving on to questions, but before then, I want to appreciate the Lagos State Chapter Chairman, MNIQS, QS Ayuba Akere is also here with us. Thank you, sir, for joining us. We thank you for your support all this time. Yeah, there is a question I received in my private message. It says, if you have a project that is 6 months and the necessary bonds, APG and performance bonds, were done by the contractor, an expiry date for the bonds are 1 year, and these are submitted to the architect. So if this project extends by another 6 months, such that it's now beyond the bond expiry date, they said, 1, will the contractor be required to provide or renew the bonds? Assume both the contractor or employer are the causes of the delays. At the cause of the delays, please note that the initial bonds cost have been included in the contract sum according to the JCT. It's a long text, but I think in a nutshell, it's just talking about the fact that a bond has been paid before. The bond that has been paid before was catered for in the contracts, in the JCT contract, maybe in the preliminaries and all that. Now you have extended the project by 6 months. Who pays this bond? I want to throw this question to QS AZUBIKE. You are the contractor, so maybe you must have probably been faced with one or two of these scenarios. Who pays the bond? Who do you think should pay the bond? I mean, bear the cost for the extra bond.
All right. Thank you, Dotun. In this scenario, if there's an EOP issued by the architect, of course, there will be a cost that will come in. Normally, what we do as contractor is we send out a cost listing out items that are affected. Most times, they are prolongation costs. In this prolongation cost, we include the cost of extending that particular bond, because if an EOP was given out, definitely it's as a result of the client delay. So every other cost that comes in. So a cost will have to be included in that in that particular prolongation cost that is sent to the client. Most times we use 6 months or 1 year, depending on the duration of the extension. It normally comes from the client and it has to be included in the prolongation cost that goes out to the client for approval.
Okay. I think, thank you for the. Anyone has any other contribution? Yes, Victor or events? Ebenezer.
Okay. All right. QS Dotun. In addition to what QS AZUBIKE has said, I want us to note one thing, that the extension of time, the claim would come from the contractor, just as QS AZUBIKE has actually mentioned. But it is a duty on whosoever the project lead is to look at the claim
Done network again.
in whole. The contractor may be asked there. Hello?
Hello, we lost you a little.
All right, are you here now?
Okay, we can hear now.
Okay, what I'm trying to say is that it is one thing on the part of the contractor to put forward a claim. The claim, you can say, oh, he's claiming for 6 months extension. But at the end of the day, it is the duty of the team lead, the contract administrator. Let me just use the contract administrator at this point. The contract administrator has to look at it, because he needs to look at the relevant events. Who is responsible for what? These events, they may be truly relevant. Are they on critical parts? This is where your program actually comes to play. So the man has to be very apt in documentation. For instance, he may say, oh, the relevant, because the contractor is supposed to list those relevant events in his extension of time claim. And when you look at it, truly this event is relevant. But is it on critical parts? No, it's not on critical parts. So there is no extension. So he has to analyze it. So whatsoever time duration that is now that the contract administrator now arrive at, put the whole lot of the liability on the contractor.
Okay. Okay. Please make it short. Okay, please go on, Yes, Victor.
If we refer to the question,
okay.
If we refer to the question and look at it critically, the person has mentioned 2 types of bond: an advance payment bond, and also, I would immediately want to go straight away the advance payment or the advance payment bond, because it is not expected that the advance payment bond is out of the picture. Now, what types of bond are in our contract conditions? We'll see advance payment bond, we'll see retention bond, and we'll also see bond for off-site and on-site materials. Those are the bonds that are in our conditions of contract, if we should observe the GCT and the NCI. Let's critically note that also has to be brought into your contract conditions. Now, who collected the bond initially? The bond was requested by the employer that should be brought by the contract. Practically, who pays for the bond? The employer paid for the bond initially because he asked for it and the particular percentage was charged. The cost will automatically want to fall back on the employer. For me, but what parties look at is first and foremost the APG will be off it. If you are bringing the performance bond into the contract, you have to include it in contract conditions so that when the chips are down, you can say, okay, this is this, is this, is this. Thank you very much.
All right, thank you, KS Victor. I struggled to hear you. I don't know, but I just believe others heard you. Then the other question is a question for the facilitator. It says, if a contractor maintains a contractor's all risk insurance for all his projects and maintains or updates this on a yearly basis, including new projects and removing completed projects, will it be, number one, will it be right for the architect or employer to request for a separate CAR insurance for a particular project? Number two, should he insist on this, then who bears the cost of the CAR? That's the contractor's all risk. Maybe this contractor has decided, he's a big guy, he's a big contractor, he has decided to do a joint CAR for his company, but at this point, the employer wants him to do separate one for his project. So what happens? I'll still go to KS AZUBIKE, the contractor. Please.
All right. As regards the contractor all risk insurance, if you look at GCT 2016, one of the schedules, I think Schedule 3, requires that the contractor must have a car insurance jointly named with the employer. That is, it has to be a joint name with the contractor and the employer. Based on my experience, which I'm not sure of every other construction company, based on my experience at where I work, we normally do car insurance separate for every project. We don't do a general car insurance for all projects. We do separate car insurance for each project because the car insurance, if you look at the sample of the car insurance we have, it carries the name of the project, the name of the employer, the name of the contractor will be in that document. I'm new to this idea of having car insurance for all projects. And if there's an extension of the project delivery time, as EBENEZER said, if the extension is as a result of the contractor's delays or whatever, then it will tell who bears the cost for the extension, be it for the contractor or for the client. But specifically, every car goes for different projects.
Okay, thank you. Let me say that maybe if there's anyone who wants to ask a question too, you can raise your hand so we can call you to ask your questions too, if you have not dropped it in the chat box. Also, I want to appreciate QS Esther Olade for staying with us too. She's a Senate member. She's a Senate member too. Thank you for in Ogun State. Yes, I hope I'm right. Thank you for being with us, ma. So, QS EBENEZER, do you have any reaction to that question? QS EBENEZER. Okay, Victor, are you available?
Yes. Okay. So what? Like I said. Okay. I guess the producer is here now.
Okay.
All right. Like Azu has said, it has to be a joint name. So in other words, it has to reference the contract in question. And if there is going to be a departure from that ab initio, it has to be spelled out in the contract. Thank you. That's what I need to add to it.
Okay. All right. Thank you. Okay, Victor, any bits?
Okay. What I said is I've had opportunity of dealing with an insurance company directly on a CRO, and I've had opportunity of feeling that the documents, you will not want to put all the risks on the employer. How do you want to share the cost? Because if you claim that you've taken the insurance on all of your equipment, on all of your distance, how do you want to share the cost? How does the employer want to pay? So aside us even talking about the contract conditions, it does not sound right. It does not look good. It does not look good, because the insurance company are going to ask you on this project, what are the equipment that are there? Put the cost of equipment. So how do you want to put the cost to the employer? Because it's supposed to indemnify them of such cost. So it does not go well. No, it does not go well.
Thank you very much. Yeah, thank you. There's another question here. It's more like painting the COVID. Yeah, thank you, Victor. There's a question here painting the COVID-19 scenario for us. It says, I have an example of the effect of COVID-19 pandemic. Very good. I said, I did a scaffolding job, which is supply and erect on site for a client mid-March. And after 10 days, the lockdown was in effect. He has done the scaffolding job. Now the employer still has 20 days to use the scaffold. The contractor was supposed to be, okay, this contractor was supposed to, okay, the contract was supposed to be for 1 month, which is 30 days. Now I am soliciting that both parties share the loss, as in the employer has to take some risks in terms of total number of days for the contract. Then it says, I'm advocating that the duration of use of the scaffold be reduced from 20 days to 10 days. I'm trying to get, the question is posted in the chat section. I think I'll have to read again. It says, I did a scaffolding job, supply and erect on site for a client mid-March, and after 10 days, the lockdown was in effect. Now the employer still has 20 days to use the scaffold. The contract was supposed to be for 1 month, which is 30 days. Now I am soliciting that both parties share in the loss, as in the employer has to take some risks in terms of total number of days for the contract. Okay, I'm advocating that the duration of use of the scaffold be reduced from 20 days to 10 days. I hope we get the twist of that question.
Well, if I may respond to that, I think in summary, what the person is trying to say is that because of the lockdown, there has been what you call downtime. You know,
yes.
So when you have stuff that is supposed to be working on site and it's not working, and and because I think at this time we have to be very, 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 very reasonable. All parties has to just be reasonable, to be honest, because you never can say it is 100% the client's fault. It's a force majeure, we know, you understand, and it's something that is unenvisaged by anybody around the globe. Let me just put it that way. So I would expect a situation whereby the two of the contracting parties come to a round table to agree on sharing the losses. That's why I say win-win in the first instance. So it should be a win-win thing, because somebody will say, oh, fine, I've lost a whole 100 days, and so you should pay me for that 100 days. You understand? If it goes back to going to whosoever he hires from the scaffold from, you understand? Maybe he has also hired it from somebody or what have you, and the person is also insisting on payment and the like. You know, this thing affects it affects the cycle of income from A to Z. So people should be reasonable. They should come to a round table and agree on what to do going forward. Thank you.
Thank you, KS Ebenezer. I think I agree with that point. We should try to be reasonable. So unless any other person has anything to add, subtract.
What I want to look at is how do we forestall circumstances like this? Because for me, how do you stop things like this from occurring? Like I said before, when things are all rosy, nobody talks about the conditions, nobody talks about them. But when there are issues, when the chief conditions, let us all try to ensure that we have standard conditions. Now, the JCT has various forms. What I mean, various forms. Now, there's 15 terms of conditions that goes with every contract. If you did not have force major, how do you want to say they should share it? So it's almost going to be a lost situation. So like the layman that's giving you the equipment or the scaffold, you might not want to listen and say no. But if you design the terms and conditions in such a way, it will not be so much to iron out, that there will be little or no dispute. So I stand at the point that let us always try to cross the T's and dot the I's to ensure that when these come up, everybody knows where they stand. Thank you, Doctor.
Thank you,
That's how I'm done.
Okay, thank you. We have something here. It says, what will be the effects of the lockdown on firm price contract projects? The effects of the lockdown. Contractors, as we said, we've had downtimes. Contractors cannot work. They have project durations already fixed. I mean, fixed before. It's going to change now. So, number one, we're going to have extension of time. But I think maybe what is still being discussed is how much of redress can the contractor get or the client get, who pays for the cost of the materials that have been wasted, the downtime on the site. You have not used your machines, you've leased those tractors, you've leased those things. You have them on site, you have not used them. Who pays for that cost? I think that's something like what the question is wound around. I don't know. Any additions, KS Ebenezer? You want to take a shot? What will be the effect on the lockdown on firm price contract projects?
Okay. Thank you very much. Thank you very much. You know, maybe I would have expected you throw this question because it in contract, you must be able to show some certain things. You understand? We talk about remoteness of some certain things when you're talking about duty of care. You understand? Should it have been reasonably foreseen by any of the contracting party of an event like this? Because there are some things, some contractual terms that I do not, I think that it will definitely when it gets to alternative solution or what have you, even to the issue of going to court and what have you, and you will know in court there are two phases. We have the common law phase. Oh, this person has stolen, should be killed. That's what the law says. And we have the phase of the equity. The equity will ask you, why did he steal? Would he have stolen if he has food at home? Now you say there is lockdown. In the first week of the lockdown or 2 weeks, people were at home. If you go outside, you hardly see people. But when the government failed in its palliative to the people, what do you see? You see people coming out. Now, it will be very wrong of you to be called in the first place. So my own take is that a lot of things may have to change in that contract, because when they are entering this, because at the end of the day, you find out that that contract will be frustrated at the end of the day, because the contractor might not be able to proceed based on those rates that you have in the contract, based on the terms that you have in the contract. It may not be able to proceed with that work. For that contract not to be frustrated, you know, they have to come to amicable resolution on some certain contractual terms. I have seen a situation. Okay, let me paint a scenario for you. They are talking about giving notice. That notice must be reasonable. QS, AZUBIKE, and I were on the same project. I'm on the consultant side. You know, there were issues on that project when this issue of fluctuation started, price escalation and the like. There was a particular subcontractor who has actually delivered his own part of the project, like 3 or 4 months ago, for instance. He's now coming back after they've even issued him, I think he's only they've issued him a practical completion certificate. He's now coming back again to claim for fluctuation because he knew. Others were claiming for it. A demand, that fluctuation that the man was actually asking for. So what I am saying is that in effect, some of these conditions you may have to shift ground. It is not a work. So
Thank you, EBENEZER. If no one has any other, I think you said it. You said it well. Or AZUBIKE, anything?
I think EBENEZER said it all. Most of these things are not well. This COVID-19 was not something that was instituted by any party. So it's not something that anybody saw coming. So I think both parties have to shift ground. One is going to affect the contractor in a very long run, because prices of this material might have gone up, and the contract is a 10-price contract. They have to shift ground, just as what EBENEZER said, in support of that. Thank you.
Hello, can you hear me? Hello, can you hear me?
Yes, sir.
We can hear you, sir. We can hear you, sir.
All right. Somebody mentioned earlier that FIDIC, about FIDIC and pandemic. Yes, in the FIDIC, there was something about epidemic that was included under the relevant events. That should there be an epidemic. Epidemic, as you will know, is a situation that is contained within a country. But when it is now worldwide, that's a pandemic. So yes, in case of epidemic, yes, it's stated in the FIDIC as part of the relevant events. Now, I wanted us to go back to the issue of collateral warranty and third party. It was said at the beginning of this session, collateral warranty and third party. Collateral warranty is a way for the employer to have a relationship, to establish a privity of contract. As you know, NEPA has NEPA has taken light here, but I can continue. I hope you can still hear me. Hello?
Yes, we can hear you, sir.
We can hear you.
All right, so pending the time the gen will come on. So on collateral warranty is the ability for the employer to have a direct contract relationship with some other parties in the process of developing a project. For instance, subcontractors. As you will know, subcontractors, they have their contract with the main contractor. So should they default and hold the project down, the employer cannot sue them directly. The employer must sue the contractor and then join the subcontractor in the suit, which may be unfair. That specialist or the may hide under the main contractor and thereby spoil the case for the client. So some clients now ask for collateral warranty. That is to say, all those third parties, let's have a contract, employer with that particular party. So that's about the collateral warranty. And so that contract, for instance also, when you have a lead contractor, a lead consultant giving advice as the only consultant with contractual relationship or contract signed with the client may also want to hold the QS responsible or the structural engineer responsible for their services. So the client may request warranties, collateral warranties from such sub-consultants. It is a way to create legal relationship that I can sue you for damages or for whatever any wrongdoing on the contract. Now we spoke about third party. Nowadays, your employer, the employer of a contract, may not even be the one putting the money down. So sometimes a developer will have gotten money from prospective buyers, about 10 buyers, 150 million. 10 is getting 1.5 billion. He wants to put up a block of 10 apartments or 12. So he's actually using the money of the 10 of the prospective buyers to build. So those putting the money down, knowing that they are putting down money for nothing that they can hold on to. So they become part of the development structure. And so they may want to also have direct legal relationship with the contractor. So should the contractor mess up, they will bear, the funders will bear part of the damages. So they may want to have direct relationship with the contractor. So that's a way that you can have established third-party rights. Now, all these were not happening before 1980. Banks were not financing, developers were not, prospective buyers were not putting money together. But since 1980, we've had this now in the JCT, that is third party, recognizing that the person putting the money down may not be the actual developer, but he also wants to secure the money he's putting down. So that's in essence why the third party rights and duties are now spelled out. And this is also an improvement that we're bringing to Nigeria that we know is occurring in Nigeria, and the NCI contract conditions has now allowed for this. So if you're using NCI contract conditions, it is good. You are now allowing for this. For this typical example, a bank wants to finance a project. The bank is not the developer, but then you can bring them in as a third party in the contract. We've had projects like that where even the insurance that you mentioned, yes, that going back to the CAR insurance, even in the insurance policy, the rights of the third party may be put there in terms of claims. Should there be a situation where there must be a claim, then who is the first payee? The first payee may be the funder. So those are parts of the intricacies of third party, but it's not too far-fetched. You can think about it, they are around us. So you may be in situations in the nearest future where you need to use those aspects of the contract. So it's good for you to know about them and be able to tell your client or even your architect, yes, they are well covered under this third party, blah, blah, blah. I think I want to rest here.
Thank you very much, sir, for chipping in for us. Okay, like at this point, it's close to 7, and I think it's good to call it a day. But okay, yeah, I want to call on the state coordinator, YQSF, QS John Agbezi. He has little words for us as we end this session. QS John.
All right. Thank you very much, Dotun. It's a privilege to have the brightest minds on a platform like this. And I must say, it's not a journey that I started today. It's some of the works that some of our leaders have taught us to do. Like immediate past president will say it's the Lord's work. And that is what we are doing. And I must congratulate everybody here, Lagos chapter members, all the Senate members are here, and all the senior members here that are on this platform, and of course the young professionals here. All this we are doing is one of the objectives of this tenure administration is to have capacity building amongst all our members, and also to ensure that we build relationships with allied industries and of course other industries like we did with Dulux the last time you saw. I know some of us, it's not easy, but we'll be counting on your support at any point in time. Especially our senior colleagues would always come to you to seek your advice, to seek your guidance, and of course be facilitators to some of our internal programs that we want to have in future. Like nobody can say is prepared for what this pandemic has brought, but these are some of the innovations that we have brought about to ensure that the COVID-19 or the pandemic does not stop some of the things that we tend to do. So we'll be counting on your support. But some of our senior colleagues will also be paying courtesy visits post COVID. And I just want to appreciate you and thank you for this wonderful opportunity. You're very welcome.
Thank you.
And of course, I must not fail to thank my executives. Is a very wonderful job that you guys are doing. Without your support, a lot of these things will not be happening, which is what we're trying to do. We're working as a unit to ensure that we bring the best to you at all times. Thank you very much once again.
Thank you, QS. Thank you, John. Thank you so much. Well, on behalf of the entire members, members and executives of YQSF, I want to say a very big thank you to our facilitators. They've been with us from Tuesday last week. Taking us through this session of what the contract says. In no particular order, QS AZUBIKE, AKWA, thank you so much. We are very, very grateful. QS EBENEZER, ADAGBADA, we are very, very, very much grateful for the time you have given to us. Even we know what it takes to even bring this up. QS Victor AKWA, we are so very, very much grateful for this.